Can two companies use the same trademark? I'm going to spend the next 4 minutes answering that question. I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to answer your trademark and copyright questions. If you have questions, drop them into the comments below. I'll answer them on a future live video. So sometimes people come to me and they're very confused because they see that two companies are using the exact same trademark. And they ask me, well, hey, I thought that wasn't allowed. Well, as in so many cases in the law, it depends on the individual facts and circumstances. So when a person or company, we'll call them the senior user, has a trademark registration, that gives them rights to prevent new users, we're going to call those the junior users, from using their trademark in a way that infringes their trademark rights. So it depends on what goods and services are listed in the senior user's trademark application. Registration. So if the senior trademark registration is for a certain set of goods, and then a junior proposed registrant comes along and wants to apply to register a trademark for goods that are completely unrelated to the senior user's goods, then that registration will issue. This is because, remember, the main purpose of trademarks in the first place is to avoid consumer confusion. So if we have, for example, why don't we just go to an example? Let's switch screens. So you can see here, we have two Ethereum marks. We have this Ethereum mark right here. I'm going to try to highlight it. So we have this Ethereum mark here, and then we have this Ethereum mark here. But why are these allowed to coexist? They're allowed to coexist because the goods and services are completely unrelated to one another, so the consumer wouldn't be confused. Let's have a look. So this is a mark, Ethereum, for building and home remodeling materials. Okay, so we have to ask ourselves, is the other trademark for things that are related or not related? Let's go look. Building and home remodeling materials, and this one is for dietary and nutritional supplements. That seems pretty unrelated to me. So we have here building materials and nutritional supplements. So what we do is we ask ourselves, is it customary in the marketplace for the same companies that produce building materials to also produce dietary supplements? If the answer is no, then there is a very unlikely chance that a consumer would be confused by looking at these two marks together, right? One is for building materials, one is for nutritional supplements. They are not sold in the same stream of commerce. We don't see nutritional supplements being sold at Home Depot, and we don't see building materials being sold at Vitamin World. So they're in completely different marketplaces. They're not sold in the same place. It's very unlikely that the consumer would even see these two marks together. So we would say that there is a low likelihood of confusion here because of the very different goods that both registrants are offering. So when you're evaluating whether goods are related, what you want to ask is it customary for companies in the same industry to make both goods? For example, it's customary to see the same people making cosmetics and handbags and sunglasses and shoes. So those would be considered related goods. So be careful out there, because goods may be related even if they're not in the same class and even if you don't think they're related. We look at the custom in the industry and go from there. I'm Angela Langlotz, trademark and copyright attorney. I'm here live on weekdays to answer your trademark and copyright questions. You can find me online at trademarkdoctor.net. I'm also on YouTube. I have a huge channel there. I think I'm up to 476 videos now. You can find me there at video.trademarkdoctor.net/YouTube. Ask me any trademark questions. Don't forget to like and subscribe so that you get all of my newest material.